A very good evening, ladies and gentlemen, guests and distinguished speaker. It is our honor to welcome you to the distinguished lecture on the role and responsibility of the trial lawyer in the dispensation of. We gather not just to explore the profound impact of legal advocacy in our justice system, but also to celebrate the dedication and integrity of those at its. I request everyone to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request Mr. Vivek Meghvanshi, Vice President Student Bar Association, to felicitate our chief. Thank you, Vivek. I now invite Dr. Deepak Kumar Srivastav, sir, Dean UG Studies, to kindly deliver the welcome address.
Thank you, Professor Garima. Honorable Mr. Justice E. Raghuram, sir, former Director, National Judicial Academy and Distinguished Juris Professor of Hidayatullah National Law University. Honorable Vice Chancellor, sir, Professor Dr. V. Vivekanandan, Dr. Vipan Kumar, Registrar, HNLU, respected deans, dear faculty members, and my dear beloved students. A very good evening to one and all present. It is a matter of great honor and pride for me to welcome you and express my gratitude for participating in the distinguished lecture on the theme Role and Responsibility of the Trial Lawyer in the Dispensation of Justice. I would like to take this opportunity to express my profound appreciation for the chief guest of today's program, Honorable Mr. Justice G. Raghuram, sir, former Director, National Judicial Academy, Distinguished Juris Professor of Hidayatullah National Law University, and revered Speaker of the Day. Sir has kindly consented to be the chief guest and deliver talk on the role and responsibility of trial lawyers in the dispensation of justice. And we feel that no other one can justify this topic except the speaker of today's program, because sir has the experience of both the side of the court, that is bar and bench. Honorable Mr. Justice E. Raghuram is a distinguished legal expert renowned for his deep expertise in constitutional law. He notably represented the state of Andhra Pradesh in a significant interstate water dispute cases related to Krishna River, including in the Supreme Court of India. Justice Raghuram embarked on his legal career by enrolling as an advocate in 1979. Honed his legal skills while working under the guidance of Sri V. Venkatramaiah, a former Advocate General of Andhra Pradesh. His excellence in the legal field was duly recognized when he was designated as a senior advocate by the High Court of Andhra Pradesh in 1995. As a senior advocate, Justice Raghuram represented diverse entities including Government of India, the State of Andhra Pradesh, Central University of Hyderabad, and prominent universities such as Osmania and Kakatiya. He also provided legal counsel to various financial institutions, including State Bank of India. In May 1999, He was appointed as an additional judge of the High Court of Andhra Pradesh and in April 2000 as a permanent judge of that court, where he continued to contribute his legal expertise till his retirement in March 2013. After the retirement from judgeship in 2013, Sir was appointed as the president of the Central Excise and Service Tax Appellate Tribunal and served for 3 years. In August 2016, Justice Raghuram Sir assumed the prestigious role of director at the National Judicial Academy, Bhopal, the first judge to be so appointed. All earlier directors of the NJ were from the academics. During his tenure of near 5 years at the NJA, the Academy expanded its judicial education and training horizons, providing training for judicial officers of several countries, including Sri Lanka, Egypt, and Bangladesh, and entering into tie-up with the Federal Judicial Center, Washington, USA, and the SVP National Police Academy, Hyderabad. Justice Raghuram Sir's illustrious career is a testament to his dedication to the legal profession and his significant impact on constitutional law and service matter. His wealth of experience and commitment to justice have earned him a distinguished place in the legal community. We extend our sincere welcome to you, sir. We swell with joy and pride to have Professor Dr. V.C. Vivekanandan, Honorable Vice Chancellor of Hidayatullah National University, our Vice Chancellor, who is a rousing leader, a rare combination of ideas, acumen, intellect, and strength. We welcome you, sir, from the bottom of our heart. We welcome Dr. Vipan Kumar, Registrar in Charge, who has been an administrative backbone of this institution and support in all possible ways. We welcome you, sir. We extend a joyous welcome to our deans, faculty, and staff members to this program. Your presence and motivation truly count. And last, but far from the least, I welcome my beloved students of Hidayatullah National University, students from ITM University who have come to listen to our esteemed speaker. Once again, it is my honor to welcome you all. Thank you.
Thank you, sir. May I now request Professor Dr. V.C. Vivekanandan, sir, Honorable Vice Chancellor of HNLU, to deliver the opening remarks.
Good evening. Honorable guest of the day, distinguished jurist professor of HNLU and a renowned jurist, Honorable Justice Goda Raghuram Garu, Registrar of HNLU, Dean Undergraduate Studies, other deans, esteemed colleagues, students of HNLU and from ITM, as well as the PhD research scholars who have joined today for this event. As you all know, we started the Distinguished Jurist Professor program last year, and we had an overwhelming support from very many renowned jurists. And Justice Raghuram Garu is known to HNLU for a few years now as a member of our governing council and has been always a well-wisher of HNLU. And when I invited him actually for a meeting tomorrow, I thought why not I weave it with a DJP lecture. He readily agreed. Then normally we give the choice to the distinguished jurist professor, and he chose this topic, which is a very vital, practical one, rather than what we call as purely theoretical stuff. So we readily agreed, and he's with us. I'm pretty sure that I never worked as a lawyer, so I really can only talk about this reading from books rather than from any experiential learning. But at the same time, as an opening remark, I thought, I'll say a few words. One thing is about trial lawyer. I don't know how many of you have seen a film which came almost 15-20 years back called My Cousin Vinny is the name of the movie. If you are not seen, please go see that. you'll really understand the whole gamut of what is trial advocacy. Joe Pesci is one other famous actor. I think you know him in Home Alone, right? In Home Alone, he's basically a comedy character actor. So he is, and Marisa Tomei did a wonderful job as his girlfriend, who actually won the Oscar for supporting role for that film. And in fact, Joe Pesci is the lawyer. And the whole thing is why I suggest to law students. The whole setting is about the court, about the judge, about a really tight-lipped conservative judge, and then Joe Pesci, who is a lawyer who is struggling to find some cases, appears for a murder case of 3 boys were indicted. Apparently they have not done and they can't afford anybody. So when they go to their aunt says, there is one relative of mine who claims to have done law and then is struggling somewhere, let us engage him. So because he is the one they can even little afford, and they say that after some time we'll pay you. And so Joe Pesci agrees and comes. And then there's a murder case. And then Joe Pesci is, the whole film is about what is happening in the courtroom, how Joe Pesci is approaching the whole matter. The best part was his girlfriend has nothing to do with law, but she will come out with some brilliant, interventions. And finally the case swings in favor of Joe Pesci, thanks to his girlfriend, who is really the trial advocate, right? Not Joe Pesci himself. So this is one film I would say that I intently watched about. Of course, films, tell many things which we write in reams of books. If properly handled, films can do. But of course, Indian films teach a different type of law to all of you, right? The court scenes and many things what we see in Indian films has nothing to do with real Indian court scenes or with any part of our law book, but they are also parallelly successful in the way they are selling law to the general public. So it is with this context which I wanted to tell as a theoretical thing about a trial lawyer, at least 5, if not the top 5 crucial things. Number 1 is to develop exceptional communication skills. The ability to communicate effectively is paramount for a trial lawyer. This encompasses not only the capacity to articulate arguments clearly and persuasively, but also the skill to listen actively, to witness clients and opposition, to identify weaknesses or inconsistencies in their narratives. The second one is to master the art of preparation. Preparation is the cornerstone of successful litigation. This goes beyond familiarizing oneself with the facts of the case and the relevant law. It also involves a meticulous approach to planning every aspect of the trial, from the opening statements to the cross-examination of witnesses and presentation of evidence. Successful trial lawyers anticipate the arguments and strategies of the opposition and prepare counter-arguments. The third, which is referred as an important element, is to cultivate strong analytical and research skills. The ability to analyze complex information and distill it into clear, persuasive arguments is very critical. Successful trial lawyers are not only proficient in legal research, but also skilled at identifying pertinent issues, applying laws to the facts of the case, and thinking critically about every angle of their approach. This is the important part. Then fostering relationships and developing a network is another important area. To build relationships with the legal community, with peers, mentors and members of the judiciary is also invaluable. A supportive network can often give guidance, advice on potential referrals. Understanding the perspectives of different stakeholders in the legal system, including the judges and opposing counsel, can provide insights into various approaches, how they want to make their point effectively to the other side. So this, apart, needless to say, which should have been the foremost, is maintaining ethical integrity and resilience. The ethical reputation of a trial lawyer is fundamental to their success. Adhering to the highest ethical standard builds trust, not just with clients but with colleagues and the court. This trust is crucial in establishing credibility, a key component in the persuasion process. Additionally, resilience in the face of setbacks and the ability to learn from failures and the persistence to pursue justice even when faced with challenges are traits that distinguish successful trial lawyers. These are all few, as I said, more from a little bookish concept which will be much more d- dealt philosophically as well as pragmatically by the chief guest. So, with these closing remarks, recently also I saw an interesting element of how the whole trial is not necessarily it is limited to lawyers. It comes from different parts of the people in law enforcement. I was just watching a film. I think that's more contemporary. You might have seen. I think a movie called Merry Christmas. There's a film which called Merry Christmas. Katrina and Vijay Sethupathi. They're a lady sub-inspector who is investigating the case, and there is a inspector who wants to shut down, but whereas the lady sub-inspector tells, and finally he makes your experience wins hands down than many of us what we are putting theoretically. So it is a question of this theory and praxis, how this chasm, how it is bridged, and that could be, in my opinion, one of the important part in this. With these few words, I rest and move to the next agenda item, to the anchor. Thank you.
Thank you, sir, for beautifully setting the tone of today's lecture. It is a distinct honor to have with us Honorable Mr. Justice G. Raghuram, sir, former Director of NJA and Distinguished Juris Professor at HNLU, to deliver the lecture on Role and Responsibility of the Trial Lawyer in the Dispensation of Justice. Honorable sir, may I kindly request to grace us with your lecture.
Vice Chancellor Vivekanandan, Dr. Deepak Srivastava, Dr. Vipan Kumar, revered faculty of HNLU, dear students of HNLU. I'm told there are some invitee students from another law school. I'm told, of course, all the faculty are postgraduates and doctorates in law. I'm told many of the students are postgraduate students of law. There are a few graduates also. In this galaxy of academic profundity, I seem to be the only compounder. But nevertheless, there are several formats of a lecture. One is a formal harangue, where it's an imposition on your human rights, and the speaker goes on speaking, and then you try to keep awake. Out of courtesy, those in the front row certainly keep their eyes open, contrary to their physiological compulsions, while the people who are backbenchers like I was when I was in school try to take a quick nap, hopefully without snoring. That's one form of lecture. The other form of lecture is a conversation, like Michael Sandel does, if many of you have seen, bring out through actions. Third is a hybrid format. First, as a former judicial officer, lawyer, had a few battles in my own time. I'll ask you,
because voice is echoing.
technology troubles old people more. I'll begin with asking you a question. All of us, whether we are physiologically, our auditory perceptions are full, or if they are impaired with a hearing aid, there are two forms of reception of auditory signals. One is called hearing, the other is called listening. Would any of you care to explain to me the difference, if you understand what is hearing? Anyone? Come on, if you want to be a trial lawyer, you have to fight. I don't want teachers. I'll come to you later. Yes, a trial lawyer will have to, any lawyer, more so a trial lawyer, will have to be bold. You have to come out. There is nothing like absolute truth. All truths in the universe, including truths of physical laws, are relative. Yes.
Hearing is when you just take in words, but listening is when you comprehend it, analyze it, and give your inputs as well.
So what is required for a cognitive animal?
We should listen, we should comprehend, we should analyze and give our inputs.
Internalize the
Uh,
auditory signal received, to put it technically,
yes.
digest it, synthesize it, and try to fertilize it with your own hard data, and then make your own image,
Yes.
and you will have your own understanding. Your understanding may be different from mine, but nevertheless that is what listening is. Hearing means that some sound waves are hitting your eardrum, either directly or through an aid, either way. So the whole game of conversation or a lecture, reception of a lecture, is about listening, not hearing. And both the lawyer and the judge should be listening, should be hearing. We are all adults, therefore I will give you not very sophisticated example of what a very, very senior lawyer, he would have been 120 had he been alive now. He told me when I was a bacha lawyer, he characterized one lawyer's argument as a bull's urine argument. So initially I didn't understand it. See, a bull, when it is tied to a cart, bullock, is tied to a cart, the poor thing, if it has to urinate, it urinates drop by drop over a couple of kilometers. Whereas a stationary bullock will evacuate till its bladder is empty. A bull's urine argument is an argument which proceeds for days without hiccup. So it's a violation of the stenographer, violation of the judge, violation of the opposite side lawyer, and it conveys nothing, no meaning. It's only it's a cacophony, not a symphony. Cacophony and symphony are both sounds. Cacophony is just random sound without synthesis, without a metric, without a meter. Whereas symphony is an arrangement of sound in a sequence, so that the outcome is music. Both are sounds. So therefore, today I will try to not go into the nitty-gritty of what a trial lawyer does not do, evidence, procedure, pleadings. All that is the nitty-gritty. I would not like to. I am now superannuated, incapable of, unqualified for employment in any institution. I will not try to hijack the role of the distinguished teachers. I have crossed the age of employment, even in academics. So I leave the nitty-gritty teaching of what a lawyer should do, a trial lawyer should do, to your revered teachers. And for a detailed session, it requires a 6-month session on the role and responsibility of a trial lawyer. I'll give you a broad evolutionary landscape of the role of law in society, the role of the lawyer. Today when you go to a court, be it a court at the first instance or the highest court, you don't get many great exemplars of law. You have people who take you for a ride on a bullock cart without springs and tell you it's an air conditioned Volvo bus, and you end up losing whatever wealth you have chasing a phantom of some delusionary success. Those lawyers are aplenty. You don't have great mentors, which fortunately we had. It's not that they are not there, but they are coming down fast. So what was our evolutionary reality? Not in the most ancient of times, but over the past couple of 100 years, maybe 1,000 years, 1,500 years if you push the envelopes. I'll begin by a famous quotation from a famous French scientist, philosopher, Jacques Monod, who perceptively observed, and this scares you. It should scare you also when you realize, and what Monod said, man must at last finally awake from his millenary dream, and doing so awake to his total solitude, his fundamental isolation. Now does he at last realize that like a gypsy, he lives on the boundary of an alien world, a world that is deaf to his music, just as indifferent to his hopes as it is to his sufferings or his success. So what Monod is saying is that there are a quintillion galaxies, each galaxy consisting of billions of suns, stars. Around each star there are quintillions of particles orbiting. Some particles form planets, some exoplanets, some microplanets, some smaller stars, some other planetary bodies, and planet Earth is one small mote of dust that is orbiting a mediocre, over middle-aged, not very significant star called the Sun. And in that planet, 18% of that planet alone is habitable. You, I, the mosquito, the recent friend we had for a couple of years, the coronavirus, we are all organic microbes in that organic slime on that 18% of this insignificant mote of dust orbiting that mediocre star called the Sun. So therefore, whenever you have delusions of grandeur, you will realize that universal cosmic vastness, and in all that vastness there is nobody to counsel you. You are alone. Either you survive with nobility or ethics and make and gather together. We all gather together today. World over, everybody gathers together. We gather in religions, we gather in caste, we gather in communities, we gather by color, we gather by gender. We form accretions, artificial accretions, which ultimately do not serve us well. These idiosyncratic accretions generate strife. That strife leads to social disequilibrium. And it is the management of that social disequilibrium that is a function of governance mechanisms in society. And the most significant of those governance mechanisms, law. Does law bring about peace? It doesn't bring about it. It brings about an equilibrium of conflict. Peace is only to be found in the graveyard. In society, you don't ever try to get peace, either in your family or the most peaceful member of your family is in the graveyard. Everybody else is in some stage of exothermic activity. Love, hate, you romance, you crave wealth, you crave position, you crave prominence, you crave recognition. And when you crave all this, the other person who is not there, who has not been able to climb as fast as you were able to climb, will feel unhappy. Somebody who has climbed better than you, you will feel unhappy qua him or her. And therefore there is tension. It is the equilibrium of tension that is the function of law, not peace. Peace is only the graveyard keeper. Absolute stillness in the night except for the nocturnal insects. Because by whatever means the disposal of a has-been human being occurs in whatever religious aggregation, whether by cremation or by internment, the complex quintillion cellular organisms regress into organic molecules, then into inorganic molecules, our original elements. That's the regression of the accretion that happens when life forms. It is not that peace we want. So what should be that deportment of your being which will prolong the shelf life of this insignificant, ugly, physiologically frail, unempowered animal called the Homo insapient, which calls itself the Homo sapient. In our arrogance, we call ourselves the Homo sapient, that is the rational among the animals. Do you find rationality anywhere? Does any dog loitering in front of a 5-star hotel, where what is thrown is a dish which when billed costs about 2,500, plate of idli might cost 2,500 in a 7-star hotel. Does any dog which is full eat that idli? It doesn't. A human being who orders, who is full, would rather eat that excess food and throw himself into the dustbin than throw that excess food into the dustbin. You call that rationality? It's not rationality. It is because we are irrational that we have lawyers. No animals have lawyers. They live in harmony. They have defined rules of engagement by which they live. They live intuitively. We live cognitively. And being cognitive animals, in the evolutionary process, when our ancestors came down from the trees, the tail was lost in the evolutionary process. It has gone to our head. That's why we are all monkeys still out there. And you still have the tailbone. It's called the coccyx. When you grow very old, post 75 or something, when you sit down, it starts, hurting you. That coccyx. That's the tailbone. We all have it. What is required is nobility, an ethical deportment which makes a large number of people get together. Yuval Noah Harari, if any of you have heard of Yuval Noah Harari, a Jewish scholar, historian, sociologist, philosopher, I would put it, he said that not more than except insects which move in swarms, the higher animals, the mammals, they can only gather together in a few hundreds at the most. But man gathers in billions. Though constantly fighting, after too long an interval of sanity, you will create some Ukraine. Because you can't live with You can't live with sanity. Sanity is a very uncomfortable position because we are essentially insane. You would like to be happier in an insane asylum than outside, telling nice stories. You create insane stories, you share them, and then you create situations like Vietnam, situations like Korea, situations like the second great conflict that we had, which consumed about 50 million people. Good for the other species, but not very good for the Homo insapient. We are constantly fighting. Why are we fighting? Because we don't have that ethical basic criteria that can bring about 8 billion people together. You know how many cells are there in the average human body? Average human body, from a person who is an adult who is, let us say, 5 feet, to another adult, an NBA player who may be 7 feet 2 inches. The average human body has 30,000 trillion cells. When you are 2.5 months fetus in your mother's womb, you have about 25,000 trillion cells, and all these cells are undifferentiated. Any cell could either become your eyebrow or your genitals or your muscles or your brain cells or whatever. After the fetus grows beyond the age of 2.5 months in the womb, the cells start differentiating. One cell becomes, let us say, the skin cells above a male's lip. Another becomes a skin cell above a female's lip, female child's lip. So the male child's cell has a memory which says that it should grow hair. If it doesn't, the male is looked down in society. A male without facial hair doesn't have the same traction in the social pecking order. A female who grows hair on the chin is similarly looked down upon. The cell remembers all this for a long time. The cell knows when it should grow, when it should not grow. One cell which is programmed not to grow, and it grows, continues to grow, you are in deep SHIT. It's called cancer. What is cancer? It's growth, right? So if 30,000 trillion cells in one human body can live for long years, sometimes for the entire lifetime of many individuals, without having cellular Alzheimer or cellular dementia or cellular lunacy, and not give cancer to a large number of people, 8 billion people, and in our country 4 billion atoms masquerading as molecules, they are not able to live together. So you call us sapient or you call us insapient. It is our arrogance that makes us call ourselves sapient. And it is because there are so many lunatics around us that some of us are lucky enough to take the profession of law. Some of you are part of the problem. You go into transactional work, where you create 10,000 templates, marry those templates, create drafts, create contracts, which you will not handle. 10 years down the line, when that draft comes up for engagement with the other company, it comes to a litigation. Some other chap or some other lady will interpret that nonsense assemblage of 10,000 templates that you have married together in a language that does not answer the grammatical requirement of any language. And that adequately English comprehending professional will interpret your khichdi of words as he or she understands it. It is presented to another fellow like me who is sitting on the bench there. For all we know, he may be sitting on a bench only because he has got arthritis and he can't sit down. That's the reason for a pedestal. And he has got his own idiosyncratic understanding of the language, because all languages are polychromatic, polysignative, and English language is chronically plurisignative. Every word means a number of things. So I understand that language as I understand English, and I pronounce an outcome. You have taken your money for drafting that contract out of marrying the 10,000 templates which your ancestors and you yourself have created. But you don't know the outcome. You are not responsible for the outcome. Some other generation is, that company is. It may be going into bankruptcy or it may be making billions, depending upon how that 10-year, 15-year later lawyer is able to sell his understanding of the language, his understanding of that necklace melange of language, to another guy or lady who is sitting on the bench. So transactional work, you are part of the problem, not the part of solution. Whereas in the practice of litigation law, of course in India, when I was a young greenhorn lawyer, litigants, legal representatives used to come on record. Things used to take 15-20 years, therefore normally you are either too old or you die, and your LR, your son or grandson or nephew, comes on record. Today lawyers' LRs are also coming on record, therefore we are taking longer time, and that is an incentive to live long. Law provides an incentive for litigants to live long, so that they can see the product of their litigious predisposition. But the hilarity apart, it's a live. One day, about 15 years ago, two senior IAS officers came to me when I was sitting working on some judgment in the evening. They wanted me to advise their son who was wanting to do law. Both of them are now retired. That child is a very senior, accomplished lawyer now. But so I wanted to impress that young boy. So I said, have you seen Enter the Dragon movie? It was an iconic movie when I had a full head of hair. So there's one young fellow who goes to Bruce Lee. He wants to join as his disciple, and to impress him he baits about 15 tiles here, there, chops. So Bruce Lee watches him with raised eyebrows and an amused expression. He says, bricks don't hit back. That's the reality. In a transactional work, your drafts don't hit you back. Maximum your senior partner or somebody who's in that law firm will say, better not this, not that. Not that he understands better. Only thing is senior to you. He writes your ACR. He then he can also make a difference to your next year's pay scale. Therefore, he has a determinative voice, like every hierarchical position in society. So therefore, you listen to him. He says, better not this, not that. That way, you delete this sentence, add this word. Nothing happens in his lifetime again. As I said, 15 years later, it's decided whether the draft is right or wrong. In a court, you are trying to make a case for your client. The other side is hitting you. Enemy. The judge is hitting you. Your client is pulling your coattails. Saab ye nahi, ye point batao, wo point batao. So it's an exothermic live battle scene where you match your wits in real time. It's not a playback. It's live. There's an excitement in that battle. So for those of, unfortunately today, when Professor Vivek entered the academics, the romance was towards transactional work. Everybody was going to corporate work. Because in corporate work, what happens? You immediately get, in those days, I think 20, 30,000 rupees they were paying when you joined the corporation, say 30 years back. Today they may be paying a lakh of rupees, the top billing may be 5-6 lakhs a month. Looks exciting. I have seen in my career, I am a first generation lawyer, 7 generations on either side of my parents never entered the court even as a witness, leave alone litigant. But then I survived. I saw, apart from after graduating from my days at struggle, in the smaller society that I lived, the who's who were waiting in my antechamber for my appointment. What happens to transactional lawyers? All those big guys, they have to wait in the antechamber of a Kapil Sibbal or a Abhishek Manu Sangvi or Mukul Rohtagi or whoever. They can't stand before a judge, because judge is not necessarily putting rational questions which you plan as you think. You know, it is said of Mahabharata war that those fellows were not wise people. They fought according to rules, therefore they fought for 18 days and killed everybody. Today what happens when Bhishma or Arjuna recites a mantra and tries to, if you have seen any of those Puranic movies, they don't immediately fire. They recite a mantra, calling names to yourself, your father, your mother, 7 generations. They call you bad names and then start the bows and arrows. So when that dharma war is going on, if somebody comes with a stick and gives a blow to Bhishma behind the head, war is over on first day. This is what the judge is doing. This is what the other side is doing. You prepare 10 points. Maybe you are right. You think those 10 points are excellent in that order. The judge is romancing only the 10th point which you thought was an idiotic point. What do? You have to immediately prioritize the 10th point as the first point and start selling. You are like a salesperson who is selling a bar of Rin to housewives. One housewife says, no, my husband is not there, please no. It's summer, May, in Raipur, hot. One housewife will say, sir, I don't need a bar of soap. Already we purchased provisions for 6 months. But you seem to be sweating a lot. I'll give you a glass of buttermilk, please have it and go. Another housewife will say, there's a bucket of soiled clothes, please wash it and show me. You have to do all 3. It's your job to sell that bar of soap, is it not? So even if you catch one client, that client will recommend another client if you wash the clothes well. So you need to understand how to wash clothes apart from selling a bar of soap. And this is what a trial lawyer does, any lawyer does. I once had a case, number of cases where these things happened, where the judge is romancing a point which you thought was not very significant. Immediately you have to say, first you have to compliment the judge on identifying the problem. So first you pocket him. This great pearl of wisdom has flown from you. I am deeply obliged for your lordship's suggestion. Mind you, even a lady judge is called a lordship. I don't know why. I once called a lady judge on my 4th day in the profession. I by-hearted. I was asking for an adjournment by 2 weeks. That's all my senior's brief. I didn't know what the case was. I didn't know what to do. These 2 weeks I by-hearted. May have it after 2 weeks. The judge was a lady judge, Justice Amareshwari of my court. With all my study of English law and American law and all that and legal history, I began with, may it please your ladyship. The senior lawyer, a 70-year-old Brahmin lawyer with a turban and lungi and all that, in Andhra Pradesh. If any of you belong to South? Any southern gentlemen? They wear that dhoti, turban, old-fashioned lawyer. he was pulling my, you know, in the gown they have a sleeve. The moment he pulled my sleeve, like the chain of a flush, I forgot what I memorized. Mate, please, mate, please, mate, please. Ladyship, ladyship. May have it after 2 weeks that I forgot. Because these are by hearted. Fourth day. This is what happens in the court. You are disoriented. Even at, and in India, you know, there is a very bad practice where everybody is simultaneously talking. It's something like an English channel, where, you know, the only thing that is not heard is rationality. Everybody is shouting at everybody else. So just short of physicality, it proceeds. It's a Bahubali scene in every, you know, news channel. Everybody is fighting everybody else and mauling everybody else in that arena, gladiatorial combat. This is what happens at the court. How do you keep your wits? How do you come back to the point where you started? So this is the challenge. But before you come to that stage, if that is what excites you, if you have in our parts, Vivekanandan, the basic sattvic food is curd rice, is it not? Suppose you live for 80 years, every day, morning, breakfast, lunch and dinner, curd rice. You don't want to live beyond a year. You need some spice and excitement in your life, is it not? So don't go into transactional work, don't go into appellate work, go into trial work. Then you come to appellate work. You will get a feel of the battle. So it will be like virtual reality, much more than that. In virtual reality, it's still an illusion. Only thing is, while the specs are on, you feel the reality of that illusion. But trial work is reality. Now, this is I try to do my best selling you to come to practice. Left to you, of course, those of you who want to come to practice. But this much I'll assure you, when you become a successful lawyer, the who's who of transactional work, the bosses of corporations will wait in attendance for your appointment. It has happened with me, a first generation lawyer. There is no reason it should not happen with every one of you. It's hard work, all right, but then you will all be there. I will skip through this paper. I'll request the university to see if they can. I wrote this paper. I was a bit preoccupied, so yesterday morning till evening I wrote a few pages, quite a few pages in fact. You might be interested in reading this. I'll request them to circulate to you. I'll just say this. Fortunately and hopefully, many of you may not go to transactional work and come to litigation. You will be lawyers. Definitely you will be lawyers. And hopefully you may even be lawyers in a democracy if you are able to keep it so for some time to come. Doesn't look very promising, but perhaps. Now, what is a democracy? Democracy is a complex and unique experiment in governance. This form of governance has received a wide measure of acceptance in modern society amongst a broad spectrum of governance models. The legal community performs a critical role in the sustenance and nurturing of democracy. Why? This is a community eminently suited to keep their fellow citizens aware of the eternal paradox that there can be no liberty without law. The legal profession serves as a rudder for the democratic boat as she and her mutinous passengers set out on the perilous voyage of government. So what is the role and responsibility of this vital profession and of the trial lawyer in that complex. And how did this come about? How did the process of reason come about? The biological explanation is that initially when we came down from the trees, and this four-legged animal liberated the four legs, stood up erect and had a greater compass of the world around it. It slowly, from initial hard times of starvation, it slowly gathered more and more nutrition. The brain became bigger, the cognitive faculties developed, and therefore though you are ugly, though you are feeble, though you are the ugliest species among the animals. When I say ugly, it doesn't mean fair skin, fair and lovely and all that. When I mean ugly, I mean compared to a lizard or a snake or a lion or hyena or a rabbit. You are not programmed for sustenance. Of all the babies, the human baby is the only baby which is unfit for survival after birth. Any other animal, immediately after birth, within a few hours or a few minutes or a few nanoseconds, it is viable. And the human baby is not, because the female form, fortunately still females are giving birth despite science and technology. The female form does not accommodate a fully formed fetus to emerge out of the body, and therefore an unfinished product comes out of the body. It has to be finished outside, not in its basic physiological components, but in those components of craft which enable it to be viable independently. And that is why it has to be nurtured by the mother in the ancient society and by the father and mother in modern society, post-pastoral civilizations. It is this puny, ugly. Why ugly? We don't have body hair. I am not talking about facial hair or the hair nowadays that grow and doesn't grow on my head. You don't have any protection against cold. You don't have a protection against the sun and the rain. And therefore, are you evolutionarily ugly? You are unprogrammed evolutionarily for survival without external aids. You need clothing, you need some bark, you need some shelter, and therefore are you among the species the most feeble and the ugliest in that sense. So don't think I'm trying to downplay your virility or your handsomeness or your beauty. The greatest turning point in the drama of evolution was the appearance of the sapient among species, the Homo sapiens. I have some more time. The defining characteristic of this puny, physiologically fragile, and the latest product of evolution is perhaps reasoning and development of thought. This is the defining mystery of our being, the reason for the survival and progress of the species. Will Durant again explained it in inimitable prose. He said, the bewilderment of baffled instinct begot the first timid hypotheses, the first tentative putting together of two and two, the first generalizations, the first painful studies of similarities of quality and regularities of sequence, the first adaptation of things learned to situations so novel that reactions instinctive and immediate broke down in utter failure. It was then that certain instincts of action evolved into modes of thought and instruments of intelligence. Pugnacity and assault became curiosity and analysis. Manipulation became experiment. The animal stood up erect and became man. Slave still to 1,000 circumstances, timidly brave before countless perils, but in his precarious way, destined henceforth to be the lord of the earth, standing erect. This is the evolutionary process of the species, the Homo sapient. Before you start romancing the successful crook or crooks among the legal profession, because of the minimum the cost of the car would be 1 crore, and they would be, if they are ladies, so be it. If they are gents, their ladies would be wearing about a half a kilo of carbon diamonds, okay, and about a kilo of metal gold. Very romantic. Before we romance this regress alone, just look at your heritage. The awesome legacy of towering intellect, deep scholarship, great moral force and vision. We tread in the footsteps and practice our craft from the values and principles distilled and refined by Yajnavalkya, Manu, Gautama, Parashara, the Buddha, Shaunaka, the Acharyas and seers, Ramanuja, Shankara and Madhava, the Sikh Gurus, the reformers, Swaminarayan, Raja Ram Mohan Roy, Dayanand Saraswati. From the ancient wisdom of the Vedas, the Upanishads and the Puranas, we remember with pride and emulate with veneration the founding and visionary men and women who formulated our organic document, the 310 men and women who sat in the wintry afternoon of 1946, fought, had different conceptions of what a liberal democracy means, how we, 250,000,000 people, can form together into a society, and formulated the Constitution of India, comprising of 385 articles and 8 schedules. Look beyond our shores into the treasures of text and human intellect of other societies which have enriched our legacy of law. The Sumerian texts and the Roman codices, the Holy Quran, the Old and New Testaments, the Judaic codices, Hammurabi, Moses, Homer, Solon, Socrates, Plato and Aristotle, Cicero, Ulpian, Wall Leibniz, Montesquieu, Justinian, Saint Augustine, Thomas Aquinas, Luther and Calvin, Napoleon, Hobbes, Locke, Hamilton, Madison, Hugo Grotius, Henry Bracton and Francis Bacon. These are a few of the infinite stars on the expansive firmament of jurists and lawgivers to mankind. Even a nodding acquaintance with this immense treasure trove of our jurisprudential genealogy provides us stabilizing, inspiring and moderating ballast for our runaway, weary or lowly impulses. Sometimes when you hear this modern music, which is all cacophony and sound, and normally all this is subsidized by manufacturers of hearing aid, modern music. The idea is to see that your eardrums malfunction so that hearing aids can be sold. That's the purpose of modern music. I'm talking about very modern music. So sometimes just before your eardrums are vanishing, you would like to listen to Western or Carnatic or other classical, Hindustani classical music to soothe your nerves. When your BP goes up and your doctor says, come to the ventilator, you would hear classical music to restore your equilibrium. It soothes you because it is cacophony converted into symphony. So whenever you see around you venality in the legal profession, think of these great people and what they have given you. And it is because of them that we are here. How does law develop? Law develop by, in democracies, people elect representatives. And today we don't sanely elect them. As I said, most of us are insane most of the time. So instead of electing a representative on the basis of what he or she can help the society in which you live, you elect them. Even the people of our socio-economic cultural class, we elect them on the basis of some fantasies, caste, community, religion, region, हमारा मोहल्ला का है, whatever, doesn't matter who it is. When you have ordinary fever, many today in small towns and villages also, they go to a doctor belonging to their caste. Have any of you experienced that among your relations? Ordinary fever, some viral fever, flu. My caste person will treat me better. Fine. When you have cardiothoracic surgery or a brain hemorrhage, you look for the best doctor. Doesn't matter if he is from another religion, doesn't matter he belongs to another state, doesn't matter you hate what he stands for, because it's a choice between life and death, or life and painful death, or death and painful death. So therefore, when you make critical choices in a democracy, you have to make rational choices, which comes only by a gradual realization. What we have achieved and what every democratic country in this world, a country I will not name it because I don't want a nuclear weapon behind my butt. A 250-year-old democracy already had one experience with a crazy guy. It's shortly going to get him again. So therefore, doesn't matter how old you are. See, just as vocabulary is not wisdom, how old you are doesn't mean that you are wise. It only means you always had dementia and Alzheimer. You grow quite old with your Alzheimer and dementia. You have dementia with a longevity. That's all it means. So democracies, they don't age gracefully. Some democracies evolve, some democracies regress, many democracies regress, and that is a nice thing for other species, because the extinction of man is the only guarantee for the other species. But since we are speaking for the humans, we would like to prolong our expiry dates. Dinosaurs had it for about 150 million years, and we are hardly, I am told, about 2 million years. We came down from the trees about 2 million years ago. All this drama happened in those 2 million years. The gatherer, the hunter-gatherer, the pastoral civilization, the industrial civilization, the information civilization, now the post-information crazy civilization. All this in the 2 million years. So how do you still make policies? Our representatives sit in the legislatures. We have our own fights based on caste, community, religion, gender, etc., etc., etc. And then in that crucible of the legislature, out of that legislative exothermic conflict, emerges a melange of policies. They are called laws. These laws are administered by a branch called the executive branch, which does not necessarily believe in that. Firstly, you need to have a philosophy to understand why laws are there. For instance, when you have one person, one vote, or rather bigamy, or prohibition of bigamy or prohibition of polyandry, that is one man, one woman. Why? One way of interpreting it is that the legislator was a sadist. He didn't want men and women to have a good time. One interpretation. Another interpretation is that it is a ration shop policy. If a handsome, rich plutocrat can have 50 wives, what is a poor fellow like me to do? That's also a hunger like any other hunger. So if that fellow also, that rich, handsome, 7 feet high, well proportioned chap having 1,000 crores can also have only one wife, and some woman will be available to me also. Same thing, because the approximate demographic arrangement is about 963 women per man world over, roughly, give or take 10 different societies. Some societies have an asymmetry like Rajasthan had till yesterday for a different reason, and they are also getting there. They are searching all over the world. They are like Apple outsources, its searches globally for its imports of elements. They are also searching now. They are realizing now. Some laws are also helping. Therefore, if you understand registration of documents, what is registration of documents? Why is the state charging money? A registration is, for those of you, if you have done your property laws, some of you are postgraduates, so you would have done your property laws. Some documents are compulsorily registrable. Why? Because the state is a sadist. State is a Shylock, it wants to make money. One interpretation. Lovely interpretations, gives you a lot of emotional satisfaction when you call somebody else a crook. A registration is a gazette notification. A registration, your teachers would have told you, does not confer title. If I am a crook and want to sell Taj Mahal and you are an idiot and wants to buy Taj Mahal, a registration officer will charge 10 crores and register Taj Mahal executed by me in your favor, no problem. When you go to Taj Mahal, Mr. Narendra Modi and Mr. Rajnath Singh will come to deal with you, because it confers no title. Registration is a public announcement of the fact that I sold Taj Mahal to you, that's all. So that another set of idiots don't buy Taj Mahal again. It doesn't give you title. It is a gazette notification or a public notification of a transaction which has some commercial value in society, which has litigious potential. So if you understand the philosophy of laws, if you understand principles of the constitution or of laws, Indian Penal Code or the property laws, Transfer of Property Act or various substantive laws, procedural laws, as except for housekeeping provisions, there are some provisions of a statute are called housekeeping provisions, but majority of provisions or majority of substantive provisions are substantive provisions in the sense they promulgate substantive values of society. So when a doctor operates on you, kills you, it's not homicide. When you kill another person, it's called homicide. If you kill another person in self-defense, it is homicide but not culpable homicide. If you kill another person not in self-defense and if you are not a medical professional, then it is homicide which is culpable. If you kill another person driving a vehicle in a rash and negligent manner, it is not culpable homicide amounting to murder, 299, 302, but it is something less than that. And if you have the same penalty for murder and theft, what will happen? Anybody? To escape imprisonment and death penalty for theft, you will kill the person also by witness. Therefore, graded penalty. For headache, 1 aspirin. For cancer, 1000 aspirins potency. Cancer pain. So, like medicine tested on the basis of trial and error, statistical method, law also does it on statistical method. I applied this medicine to 1000 patients, 999 patients got cured. I applied this penalty to this delinquency in society, 999 people behaved well. One fellow is always delinquent. So he has to be dealt with by chemotherapy, not by ordinary chemical medicine. That's how law operates, like medicine. Statistical man has not invented any other method. Even religion has not invented any other method. If you do good things, do punyam, we call it in South, I don't know what you call it here. Punya or pap, hai na? You will go to God. That is what law aims for. And all the ethics of law that I have dealt with in this, I think 28, 27 pages, deals with that. I would request you, I think I have already imposed quite a extended duration of human rights violation on you, and I won't trouble you. I would, those of you who are interested, I'll make out a bibliography of what you should read and pass it on to the faculty so that they can share with those who are interested. Always happens, you know, when I was training judges, I categorized them into 3 categories. One, already there, one, trainable, and the third category is untrainable. Untrainable, we suffer. They are unadulterated and unadulterable by law. In every profession there are some species like that. We don't reach out to them. Those who are partly adulterated by law and are likely to be adulterable by law and are willing to learn, only those people we target in judicial training. Legal training is also like that. Right now it's theoretical, it will be battled shortly, and I welcome you all to that exciting drama called practice of law. Thank you.
Thank you, sir. It was indeed very insightful.
I didn't want to read it. Yeah.
Honorable sir, it's my privilege to inform you that our audience with brimming enthusiasm has shared with us a few questions. To facilitate a structured and efficient interactive sessions, I will be announcing the names of the participants who will stand at the respective seats.